Welcome everyone to the Credit Concept Podcast. I am your host, Credit Coach Nicole Scott, and in today's episode, we're going to be breaking down collections. Should you pay that collection that's on your credit report or should you not? That is one of the most common questions that I get asked as a credit coach. What should I do with this collections? Should I just pay it or should I dispute it? We're going to be breaking down all of that. Now, my short answer to all of this is always dispute the alleged balance that they say you owe first. If you have gone through the dispute process and say it's been 3 months or 6 months max, and they're able to validate that this debt truly belongs to you, and in that case, I would recommend that someone just settle it. It's also all about how fast that you're trying to move. Each person has different goals and a different timeline that they're on because every person out there is on their own journey. And that's why we talk about the concept. The concept is you put the concept in place and you apply it to best fit your goals in your life. Okay. Always do your own research. Never take my word for it. Okay. Always take the information and make an educated decision on what is going to be best for you. And please stop listening to all of these gurus on YouTube University, okay? There are a lot of people out there that are simply going to give you their opinion. Guess what? These people are not lawyers and they should not be giving legal advice. Just so you know, I am not a lawyer. I do not give legal advice. I give you the concept based on my personal experience and professional experience in helping not only myself, but thousands of other people deal with collection accounts that are listed on their consumer credit report. If you know the debt belongs to you and you want to just simply get it past you, then of course settle it. All right. And we're going to be breaking down all of the different types of collection accounts that are out there because there is a difference. And a lot of people don't realize that there are 3 different types of collection accounts that could possibly be reported on your credit report. The first are going to be junk debt buyers. Those are going to be collection companies like LVNV, Midland, some of those more popular places that you're going to see on your credit report because they buy junk from creditors. The 3 different type of collection accounts are junk debt buyers, debt collection companies, and then we have charge-offs. Charge-offs are generally still with the original creditor that you defaulted with or allegedly defaulted with. So let's take a deep dive into junk debt buyers. And these are basically collection companies that purchase junk debt. Okay, they buy defaulted credit accounts from companies. These can be credit cards, personal loans, auto loans, or even student loans. They buy this debt for pennies on the dollar and then they try to collect on this junk debt. Junk debt is often referred to as zombie debt. Often the claim is started with the collection letter they sent you. It's also known as the dunning letter. That's the first letter that they use to communicate with you about the alleged debt. If that part is unsuccessful for the collector, then they could proceed with a lawsuit. Now, they cannot file a lawsuit if you are outside of the statute of limitations for your state. Every state has a different statute of limitations, but in my state of California, the statute of limitations is 4 years. So nobody can sue me for any sort of alleged debt if I have already passed that 4-year mark, and that 4-year time ticking bomb starts the first time that you became delinquent. So 4 years from the first date of delinquency is when, if they're going to sue you, they have to sue you within that first 4-year period. After it has been 4 years past the first date of delinquency, they can no longer sue you for this alleged debt. That's the good thing about it, right? Now, often the claim is taken up with if you do get sued for this alleged debt, you need to show up. You do not want to ignore it and think that it's just going to go away, because it is not. Once you have received any sort of documentation from the court or you have been served, you need to show up to at least defend yourself or hire a consumer lawyer from your state to help you with defending or settling the case at a fraction of the amount of the claim. You can also settle accounts yourself if you are good with negotiations. It's all about negotiations. Generally, you can settle these accounts for 50 cents, 30 to 50 cents on the dollar, because again, it's all alleged. So they've paid anywhere from 2 to 3 cents on the dollar. They would be more than willing to accept 30 to 50 cents on the dollar from you, because that is a profit. Now, we all might wonder where the term junk debt buyer comes from. And basically what happens is, say, we're just going to use you as an example, and I hope that you don't mind. So we're just going to say that you had a credit card, right? And this is just an example. I'm not saying that you would do this. We're just using you as an example, and I thank you for that. Okay, we're going to say you defaulted on a credit account. The original creditor, who is, say, Capital One, they attempt to try to collect on this alleged balance that you owe them. Now, if the original creditor, which Capital One is the original creditor, if they fail, then, of course, failing to collect the debt from you, they would then charge off that debt. The charge off is an accounting term that means uncollectible debt. Generally, that charge off will happen once you have become 90 plus or 120 plus days delinquent on the account. And I never recommend doing this. Don't ever just put your head in the sand and say, hey, I just don't want to pay my credit card debts. That's the biggest mistake that people do. You can literally just pay the minimum amount due and try to, make it work for the time being so it does not end up costing you more in the long run. All right. But, things happen. And if this was in your past, I totally understand. I certainly have gone through it myself. So I get it. Sometimes things happen, but don't ever just do it on purpose. That is the worst thing that you can do. It's like shooting yourself in the foot. You don't want to do that to yourself. Okay. So now back to this. Now, once the charge off is completed by Capital One, then and of course, once it's charged off, it does not mean that you no longer owe the debt. After the charge off has happened, the defaulted account is placed with other defaulted accounts into a portfolio per se, right? And the portfolio is sold to the highest bidder, which is a junk debt buyer. The junk debt, because the original creditor the debt is junk, quote unquote, because the original creditor was not able to collect on it. So they view it as trash in their opinion. They're like, look, we can't do nothing with this, so we might as well sell it to you and let you try to do something with it, okay? And the original creditor, a lot of you guys say, well, what about the Fair Debt Collection Practice Act? What about that? Well, guess what? The Fair Debt Collection Practice Act, which is the FDCPA, it only, is in effect for collection companies. It does not apply to the original creditor, okay? So the Fair Debt Collection Practices Act is only for debt collectors, okay? And we'll get into that a little bit later on, but, back to this whole junk debt buyer thing, they just look at it as junk because they couldn't collect on it, okay? Now, some of the largest junk debt buyers are Midland Credit Management, which you might see MCM, and Portfolio Recovery Associates. Those are the two most common. Now, some of the, other ones out there, because there's tons of them out there, right? But some of the others that you may have seen in the past, LVNV, Atlantic Credit, Unifund, Velocity, there's, Midland. So there's a ton out there, and those are junk debt buyers, okay? They buy junk debt from original creditors, okay? There are certainly others, but these are the primary ones. Usually it's like Midland, portfolio, LVNV, and Calvary. But people often say, I didn't agree to that, or they can't sue me because I did not agree to the sale of this debt. But your agreement is not necessary when it comes to the purchase or the sale of defaulted credit accounts. What matters is whether the junk debt buyer actually bought your account, and most importantly, if they can prove it in a court of law. Credit card accounts can be sold. There's nothing illegal about that. They are an asset to whomever owns them. And this type of sale is perfectly legal. Okay. And so that's why I say sometimes you have to retrain your brain on everything that you once heard or thought, because the important thing now is how you handle this issue once it gets into the hands of this junk debt buyer. Now, the proper course of action is always to dispute the debt and request validation. And if they do happen to take you to court, you can go and, stand in and deny or try to settle the alleged account, or you can consult with a consumer attorney that is out of your state to help you. But don't just ignore the situation. Once you default on an account, the original creditor actually obtains the right to sue you for the balance owed. And this is called a legal interest. Any legal interest can be sold to anyone for any price, and the individual has nothing to say about the transaction. Okay, so we pretty much, have no control over that. All right, once you default on something, it's definitely, it's a negative for us. Okay, in my experience, I have found that most junk debt is sold for anywhere between 2 and 4 cents on the dollar. So the junk debt buyer will attempt to collect on the debt, and this usually starts with a phone call or a letter, but it could easily escalate to filing of a lawsuit, especially when you start disputing it, or they feel like they've got you, because this is what they do. They file lawsuits against people to scare them into paying. And sometimes it's just simply not accurate. Sometimes, you do have to fight for yourself and stand up for yourself. And don't be afraid to do so, okay? Because believe it or not, a lawsuit from a junk debt buyer can often be to your benefit. In my experience, I've found that a lot of junk debt buyers often do not acquire all of the necessary documentation that is needed to prevail in a court of law against debitors, which are, the individuals who owe the money or that have defaulted on the credit account. Now, the typical package that a junk debt buyer acquires usually consists of the debtor's name, address, telephone number, account number, charge-off date, and the amount that they allegedly owed, and many other documents and pieces of evidence that are needed in the court of law are simply not there. They don't have them. In most instances, the junk debt buyers have, a severe difficulty in obtaining these key pieces of evidence that they would need to validate and prove beyond a reasonable doubt that this alleged debt belongs to you, and that the breakdown in the accounting records, is accurate, okay? Because oftentimes they put in all these additional fees and, you might owe, but not that much, okay? And if they cannot acquire the documentation from the original creditor, then they simply cannot win. So the key is to really, get yourself as much knowledge as possible, or to consult with an attorney. Again, I don't give legal advice. This is simply from my experience, but it's a great way that you can allow these junk debt buyers to take you to court and win, because they simply don't have the proof that is needed in order to prove it in court. But they are going to sue you because they know those are different scare tactics that they can use to get you to pay, right? And if you just want it to go away, you can settle it. If you plan to settle debt, try to go 30 cents on the dollar first, then 35 cents, then 40 cents, then 45 cents, and max is 50 cents on the dollar, okay? And that way you can settle it and it goes away. Now, that is junk debt buyers. Let's talk about debt collections. That's different, okay? Because there are debt collection companies out there, and those are companies that have not purchased the debt, but they are trying to collect on an alleged balance from a service provider. Usually that's medical, utilities, cell phone companies, cable companies, things of that nature, okay? And those are your most common debt collectors. And, they have to follow the Fair Debt Collection Practices Act. And so do junk debt buyers, because even whether they're a junk debt buyer or they're a debt collector, they still have to follow the Fair Debt Collection Practices Act. And let's talk a little bit about that, because it's important to understand your rights under the FDCPA for not only yourself, but for you to understand in case you plan to start a credit repair business, because you do have rights. So the debt collection companies are not allowed to contact you, during certain times, and they have to follow certain rules, okay? So they cannot contact you before 8 a.m. or after 9 p.m. unless you have agreed to it, which I never recommend. They cannot contact you at work if you tell them that you're not allowed to get calls there. They cannot contact you by email or text message or social media if you ask them to stop. They cannot call you more than 7 times within a 7-day period or within 7 days after talking with you by phone about a particular debt. They cannot privately message you on social media if you ask them to stop. Now, how are debt collections allowed to contact you? I would recommend debt collection companies contact you in writing via mail, okay? Via regular USPS mail. And if the debt collection company has contacted you, you request validation, okay? Now you can request that they provide you with the validation information about the debt, either when they first communicate with you or within 5 days of the first contact. They are required to provide you with their name and mailing address, the name of the creditor that you allegedly owe, okay? How much money you owe, written out to include interest, fees, payments, and credits. So you want a schedule of the breakdown of, the accounting. And what do you do if you don't think the debt is yours? You need to contact them in writing. Do everything in writing so you have a record of it. Your debt collection rights, including your right to get information about the original creditor if you ask for it within 30 days of getting validation information from the original creditor. That is your right. They have to give you validation. Now, how do you stop a debt collector from contacting you? You would mail a letter to the collection company, and which is like a cease and desist letter, okay? That basically tells them to stop contacting you except for in writing. Now, if you don't want them to contact you at all, you can simply write them a cease and desist letter, but I would recommend cease and desisting all forms of communication except any forms of written communication via USPS mail. Keep a copy for yourself. Consider sending the letter by certified mail and paying for a return receipt. That way you'll have a paper trail that the collector has received it and signed off for it. Now, once the collection company gets your letter, they can only contact you to confirm it. They will stop contacting you in the future or to tell you its plans to take a specific action like filing a lawsuit. And if an attorney is representing you, then you tell the collector, and the collector must communicate with your attorney, not you, unless the attorney doesn't respond to the collector's communications within a reasonable amount of time. But consider talking to the collections at least once, especially if you don't think that you owe the debt or you can't repay it immediately. That way you might be able to confirm whether it truly belongs to you or find out more information about the alleged amount that they say you owe. Do not share any sort of personal or financial information until you have gotten validation information, or that you have confirmed that this debt collection company is legit, they have a license in your state to collect, and they are not a debt collection scammer company, because there's a lot of those out there as well. That's why I always say never pay it unless you've gone through the validation process and you know that, hey, this is mine, I just want to get this behind me. Once I pay it, they've agreed to stop reporting, so on and so forth. And that's called a pay for delete. You're going to pay the debt collection company for the alleged balance. You're not agreeing to it, but you're settling on an amount, and they're going to update it to 0 and stop reporting that you currently owe a balance to them. In most cases, they'll just take it off your credit report. If they don't, you can dispute it, because there's no reason why a collection account should still be reported if it's already paid. Okay, so you can most definitely dispute the account once it has settled if you decide to go that route. Now, can a debt collector contact anyone else about your debt? Generally, a debt collector cannot discuss your debt with anyone but you or your spouse. If you've told the collector that an attorney is representing you, the collector can contact the attorney, and most likely will. Collection company can contact other people to find your address, your home phone number, or where you work, but usually it cannot contact them more than once, and they can never tell them that you owe a debt. They just say that it's in regard to a personal business matter. Now, what do you do if you don't think you owe the debt? Now, once you get the validation information from the collection company, you can dispute the debt with them. You can dispute it by phone, but I recommend disputing it via writing, okay, in a dispute letter. You can use ChatGPT to draft you up a nice professional dispute letter to the collection agency saying that you don't owe some or all of the money, and you can ask for validation of the debt. And make sure to send the letter within 30 days, because that is going to be very important. Once you get that first notice in the mail, you have 30 days to dispute and request validation before they report it on your collection, or report the collection on your credit report. That's also known as the dunning letter. That's the first letter that they send out to you to determine if you're going to, dispute the validity of this alleged debt. Once the collection company gets the letter, it must stop trying to collect the debt until it sends you the written verification of the debt, like a copy of the original bill of the amount that you owe. Again, it's a copy, not the original, like that has your ink signature. You're not going to get originals. So I heard someone say that one time, and I was like, oh my gosh. Again, opinion, okay? But yeah, we live in the real world where they are just going to have to give you a copy of that. But you can consider sending your dispute letter to them via certified mail, again requesting a return receipt to show that the collection company received it. You can also email it to them if they have an email address, because that is going to give you a paper trail as well. And then keep a copy of the letter that you submitted or the email that you submitted. Keep a copy of that for your records. So I recommend, if you're doing a paper trail, you have everything in like a folder or a binder. If you're like a person that does everything online, create a Google folder and upload all of your proof to your Google Drive. So that way you have everything in a folder and you are organized. And again, you have that paper trail, because if you don't have the paper trail, you're not going to win in court. That's how people lose. You need to make sure that you keep that paper trail. Now, what are debt collectors not allowed to do? They are not allowed to harass you, okay? They are not allowed to put logos on the outside of their envelopes to make you think that they're, a collection company. They cannot threaten you, okay? Threaten to hurt you or threaten you. They cannot use obscene or profound language. They cannot call you more than 7 times within a 7-day period, or within 7 days of talking with you on the phone about a particular debt. A lot of debt collection companies get in trouble for that. So again, keep record of every time they call you, keep record of everything from phone calls to text messages. If they contact you on social media, you keep record of everything. Collectors can't lie, okay? They cannot tell you that you owe a different amount than what you actually owe. They cannot pretend to be an attorney or from the government. They can't tell you that you'll be arrested or claim that they'll take legal action against you if it's simply not true. They are not allowed to treat you unfairly. They are going to try to scare you. Yes, they are. They are going to try to say that they're from a law office. They are simply a debt collection company, okay? Don't be fooled, okay? And again, all of these collection companies must be licensed and they must follow all of the Fair Debt Collection Practices laws, the FDCPA, okay? Now, they also cannot try to collect interest, fees, or other charges on top of the amount that you owe unless the original contract or the law says that they can, which in many cases they cannot, okay? They cannot deposit a post-dated check early. They cannot publicly reveal your debts. So that means that they cannot send you a postcard or put any information or logos on the envelope that they send you in the mail, okay? Some do, and they get in trouble for that. Now, what you need to know about if you decide to repay the debts, just to get it past you, okay? You can most certainly pay a debt collector that is trying to collect a debt from you, and they can apply any payment that you make to the debt that you choose. A debt collector can't apply a payment to a debt that you say you don't owe. Okay, so just keep that in mind. If you are wondering if a debt collector can report your debt to a credit reporting company like Experian, Equifax, or TransUnion, yes, they absolutely can. There's nothing illegal about that, but a debt collector must take one of the following actions before they report a debt to a credit reporting company. They must talk to you by phone or in person about the debt, or they must mail a letter or send electronic communication about the debt, such as the validation notice. Generally, again, this is known as the dunning letter. And wait a reasonable amount of time, usually it's anywhere from 14 to 30 days, and allow you the opportunity to dispute or deny this alleged claim, okay? Now, they also need to wait to make sure if they do mail you a letter, if it's returned, of course, they can't start that time frame. So that's why it's so important for you to communicate in writing to them, whether it's email or mail, to dispute the validity of that alleged debt. Now, say, for example, you get a lawsuit and they get a default judgment and you have a garnishment. Now, a debt collector can absolutely sue you, but again, you have to show up to defend yourself. Now, you are allowed to respond either personally or through an attorney to preserve your rights, but don't just ignore it, okay? And yes, a debt collector can take money from your paycheck or your bank account. What this is called is a garnishment. So the collector will sue you in court. If you don't show up, they will get what's called a default judgment, okay? Once the collector receives a default judgment, because they've sued you and you didn't show up, so they got a default judgment, they will get a court order called a garnishment. That says that they can legally take money from your paycheck to pay your debts. A collector can also get a court date to take money from your bank account. So do not ignore the lawsuit, or you might lose the chance to fight a court order. And guess what? A lot of people always ask me this: can a debt collector take money from my federal benefits? Oh, this is a good one. Meaning your Social Security benefits, your federal student aid, your benefits from, say, like railroad retirement, veterans benefits. Many federal benefits are generally exempt from court-ordered garnishments in states that have their own laws about which states, benefits can be garnished, okay? But generally, federal benefits are generally exempt from garnishments, except to pay delinquent taxes, child, spousal support, or student loans. But they cannot take your Social Security benefits. They cannot take your veterans benefits. They cannot take supplementary security income benefits. They cannot take federal student aid. They cannot take military annuities and survivor benefits. They cannot take railroad retirement benefits. They cannot take federal emergency disaster assistance. So that's also very important to know, because you don't want these people to try to, scare you into something to pay. Okay. And keep in mind also, there is a debt that is time sensitive. So they can only sue you within that, depending on what your statute of limitations is in your state. I'm in California, so it's 4 years. They cannot sue you after 4 years from the first time that you became delinquent. Oftentimes they'll try to change that date of first delinquency, but they can't. It's against the law, okay? But again, debt doesn't just go away. Debt collectors do have a limited time to sue you in the collection of the debt, and this time, again, is called the statute of limitations, but it usually starts once you miss that first payment on the debt. And after this statute of limitation runs out, your unpaid debt is considered time barred. How long the statute of limitation lasts really depends on what kind of debt it is, because there are different types of debts. And again, the law in your state specified in your credit. The statute of limitations really depends on the different type of debt it is and the state that you are in. Different states have different laws. And again, there's all sorts of different agreements as well. In some states, if you make a payment or even acknowledge in writing that you owe the debt, the time clock can reset and a new statute of limitations begins. In that case, your debt is no longer time barred. So that's why it's really important not to communicate with the debt collection company or admit that it's yours. Don't talk to them. Simply request that they send all communication in writing. If a debt is time barred, it is against the law for a debt collector to sue you for not paying it. If you do get sued for a time barred debt, tell the judge that the statute of limitations has ran out. And sometimes, depends on which state you live in, some state laws say it's illegal for a debt collector to contact you about a time barred debt. And other states, it's allowed. So either way, they can't sue you, but again, they might try to collect from you, but they are not able to sue you or even threaten to sue you over it. If you are in a state where the debt collector can contact you about a time-barred debt, they can keep contacting you by phone, email, or letter to try to collect on what they allege that you owe. If you want to stop them, you simply write them a cease and desist letter, and that can be done on ChatGPT, write me a cease and desist letter for this collection agency. That way you've got record of it and they can no longer contact you. Oftentimes they might resell the debt to another junk debt buyer, and this is really common when you get one collection account for this same account deleted from your credit report, and then a few months later that same collection account pops up under a different name. That simply means that they could not collect on the debt and they sold it to another junk debt buyer who's going to try to collect on it. But here's a little tip: if the last company could not collect on it, chances are it's uncollectible, so you just need to keep disputing it. Unfortunately, it's the game that we have to play here. A lot of people ask me, do I have to pay a debt that's considered time barred? It's up to you. I mean, I would consider booking an appointment to speak with me directly, and I can give you my honest feedback. But, the choices are really, hey, you pay nothing and the collector can't sue you, but they can keep contacting you unless you send a letter by mail telling them to stop contacting you. You can, pay the debt off, and, again, that's your decision if you decide to go that route, because sometimes if they are reporting it on your credit and you have to buy a house, you might just need to pay it off, right? Or you can make a partial payment. In some states, even if you pay any amount on a time-barred debt or even promise to pay, the debt is considered revived. That means that the clock resets and the new statute of limitations begins, and the collector might be able to sue you to collect on the full amount of the debt, which may include extra fees, court costs and things of that nature. They can also collect interest. So I never recommend making a partial payment. Either settle it off or pay nothing, do nothing, and just keep on disputing it. And that is something that a lot of people do and that they recommend to a lot of people. Now, keep in mind, there are also considered charge-offs. Charge-offs are completely different. Charge-offs are generally with the original creditor. Now, if you are going to settle any sort of collection account that is on your credit report, I would recommend that you settle charge-offs. Charge-offs are the hardest type of account to get deleted from your credit report because they are still with the original creditor. And here's an example that I can use with you guys. So Chase, which is the #1 bank in the United States, if you owe a old debt to Chase, generally they are not going to sell it. They are going to try to collect in-house on it. And that is something that I would recommend just paying off because, again, you can still settle the debt. You don't need a debt settlement company. You can do it yourself and start at 30 cents on the dollar. Work your way up to 50 cents on the dollar. But settle, negotiate, okay? If you have to speak with a manager, get a manager on the phone. If you have to disconnect the call because they're not listening, do that and try again later. But let them know, hey, look, I am trying to settle this. I went through a financial hardship. I'm trying to make right with you guys. I can afford to pay X amount of dollars to update this to a zero balance, okay? Because at the end of the day, that's what we want. We don't want any charge-offs to report that we still owe a balance, because what happens is they are still every single month reporting that you have an active charge-off / collection account. Okay. And that is just bringing your score down. You are literally just hemorrhaging points. Once you patch that up where you're not losing points every month from that negative account reporting on your credit, and you replace that with positive, your credit score is going to go up. Okay. And anytime you're going to buy a house, you can't have any loose ends. You need to tie all of that up before you get approved, or else it's going to affect your debt to income. Okay. And let's just be honest. A lot of creditors, banks, and financial institutions simply don't want to see those type of negative accounts on your credit report. They're going to give you a lot better terms if you get all of that stuff patched up, cleared up, and straightened up before you go to them and say, hey, pull my credit. Okay. Don't let them pull your credit and they're like, look, you got all sorts of stuff, so we can't even help you right now. Okay. You need to work on your credit first. Understand exactly what's on your credit report, what you need to do. And if you need to book a call to do so, do so. Okay. But again, guys, make sure that you have subscribed to the channel. You turn those bell notifications on. I'm going to leave a list below of all of the other episodes in the Credit Concept podcast, because I talk a lot about, what you should do in regards to different things that could be, you could be dealing with. In this case, we're talking about collections, but this is a very common thing. And what a lot of people also fail to realize is, collection companies, they're not all the same. So if they are collecting on behalf of, say, a utility company or a doctor's office, then you're going to have less room to negotiate with them, because they're going to need to go back to their client and see if they're willing to accept that from you. So you're going to have less wiggle room to negotiate when a collection company is a debt collection company and they are collecting on behalf of their client. They do not own the debt. They are simply hired by a service provider to collect on their past due accounts. Okay. And once you have settled up your past due account with the debt collection company, generally they will no longer report that to your credit report. Okay. They can't negotiate with you or make promises that they're going to do a pay for deletion, because that is illegal. They're not able to barter with you. Okay. But in so many words, once you have paid the debt, it is no longer going to be actively reporting as a collection account. And you can dispute that directly with the credit bureaus to get that off. You can send proof of payment. You can send proof that you settled the account and that this collection account is no longer valid and should be deleted from your credit report. Again, use AI to write all of these letters to the credit bureaus or to the creditors or to whomever you have to write to, because a lot of people are like, well, I just don't know how to write it. I don't know how to put it on paper. We don't have to worry about that anymore. We have ChatGPT. It is free. You can sign up for a free account, okay? Just make sure that you are using like a Google Doc and put your letter in there and save a copy for yourself and keep good records. You can also use, Credit Repair Cloud. If you plan to start a credit repair business, I have a playlist on that, on how to do that. But, in regards to collections, in so many words, once you have disputed it and the debt belongs to you, especially if it's with the original creditor like Chase or American Express or any sort of big bank, you need to just settle that, because they have the documentation, they have the records that you paid that account in the past from, your bank account. They're not stupid, okay? It is 2024, okay? Stop playing games. We can't get away with everything. It is getting harder and harder to run from our debts. Now, some things we can get away with, right? Because they're simply not able to prove it. And if they can't prove it, they got to remove it. So prove it or remove it. That's the motto that I like to stick by, guys. So again, if you haven't by now, make sure that you have subscribed to the channel, Credit Coach Nicole Scott. You can also follow me on Instagram at Credit Coach Nicole Scott. Make sure to turn those bell notifications on and watch all of the other episodes in the Credit Concept podcast. If you check out the description below, I have a free credit starter kit that you can get. It has a list of financial institutions that you can start building a relationship with. It has a bunch of great information on personal credit, business credit. We've also got our different courses. I've got the funding course out now. It's only $24 in the year of 2024 because I want you guys to get this information, okay? So if you do need additional help, or you feel like you want to get my opinion on what I would do if I were in your shoes, or if you need help with debt settlement, any of those things, feel free to book a call with me. The link is in the description, and I can give you my honest feedback on whether or not I can help you, or whether you need to contact a consumer attorney that is in your state, because everyone is at a different place in their journey, and everyone's journey is different. There are so many different avenues. There is so much gray area when it comes to this whole credit world, and there are so many different people that are going to give you their opinions on their, what they would do, or their professional advice. And oftentimes, you are going to hear a lot of credit repair people say, oh, don't pay it. Sign up for credit repair. Let us dispute it for you. Let us delete it off your credit report. Okay, you can dispute things on your own. You don't need a credit repair person to do that, okay? If you know the debt belongs to you, and you're like, hey, I've disputed this multiple times, I know it belongs to me, you're better off just trying to settle up your old debts and work on debt settlement. Don't sign up with a debt settlement. I would recommend speaking to me first, because the debt settlement companies are a crock of what. They just take your money and don't do nothing. You need to deal with a coach that's going to help you walk through it. Not only have I been through this myself, okay, I totally have been through this myself, okay, I've been there. I was considering filing bankruptcy at one point. Thank God I did not, okay? But you definitely want to get someone's honest opinion, who is not trying to sell you on anything, who is going to give you their honest opinion on what I would do if I were in your shoes. And this is just based on my personal and professional experience in the credit space, okay? Because a lot of consumer attorneys, they're going to tell you, hey, if the debt is yours, you got to pay it. And they're just going to try to negotiate a lower rate, but you're paying them sometimes $500 an hour, okay? So there's, obviously something that might not be in too many people's budgets. So you just have to come to that realization like, hey, this is not going to go anywhere. They've already validated it, especially if it's with the original creditor like Amex or Chase or Navy Federal or any of these big banks that are trying to collect from you. It's very challenging, but always go through the validation process first, dispute it, go back and forth with them, 3 to 6 months, depending on your timeline of when you need things done. And if you need help, I'm here. Reach out, book a call with me. I appreciate you watching. You could have been anywhere else today, but you chose to listen to me ramble on about collection accounts. And I know it's not fun, but I'll tell you what, I'm always going to keep it real with you guys. So if you have any other topics that you would like for me to touch on that I can help provide value, let me know in the comments, guys. Thank you so much for watching. Make sure to watch the Credit Concept playlist coming up next.